This is Democracy Watch. So, Mark, we have some startling news from the U.S. Supreme Court. It's effectively allowed for the criminalization of mass protests in 3 U.S. states. That's Louisiana, Mississippi, and Texas. Talk about what just happened here.
So this is really troubling. This all stems from a protest that took place a number of years ago, sponsored by Black Lives Matter. And the individual who put the protest together, which involved thousands and thousands of people, is being sued by a police officer who had been injured at the protest for civil damages for those injuries. And, historically, we all kind of assume that, if you're the guy who throws the brick that injures, for example, a police officer, the police officer can sue you. But if you're just the guy who, organized the protest, and there are tens of thousands of people at this protest, you're not responsible for the acts of everyone in the crowd. And what happened is this case has gone up and down the federal courts, but the Fifth Circuit Court of Appeals, a court you and I have talked about before, decided that this police officer in Louisiana can sue the organizer of the protest, who did not throw a bottle, did not throw a brick, was not involved in any of the violence at issue, but can sue them because they organized the protest and collect money damages if they were negligent. Negligent is the term here for the way in which this protest was organized that allowed this violence to take place. And look, the fact that the Fifth Circuit went off the rails a little bit, not a huge surprise given what you and I have talked about before, but we all assumed that the U.S. Supreme Court would then reverse that. Instead of reversing it, the Supreme Court didn't take the case, and so that Fifth Circuit opinion is now the law of the land in the states covered by the Fifth Circuit, which includes Louisiana and Texas.
Well, wait, isn't there already a Supreme Court precedent that prohibits exactly this, that prohibits holding an organizer of a protest accountable for any financial damages sustained by somebody in the protest?
Yeah, so it's actually even clearer than that. There is a very old Supreme Court case that says that you can't hold the organizer liable. Okay, and that is the controlling case that should have put an end to the Fifth Circuit's inquiry here. But even more startling about why that the Supreme Court didn't take this case is that after the Fifth Circuit ruled in this case, the current U.S. Supreme Court decided another case in Colorado involving that involves sort of cyber stalking and what's called the True Threats Doctrine, in which the current Supreme Court reiterated that what the standard is for threats that cause violence. And though that opinion came out after the Fifth Circuit ruled, everyone assumed that the current Supreme Court would use that more recent precedent to summarily reverse this Fifth Circuit decision and overturn it. And instead, the Supreme Court didn't, which was called out by Justice Sotomayor in her dissent.
Well, the obvious question presents itself here. What about the First Amendment and the right to protest? How does that reconcile with this decision, or this lack of a decision?
Right. So it doesn't. And this is, like the cynic in you, the cynic in us would say, so there is this old case that, is still controlling law, has been viewed as the controlling law from the Supreme Court, that seems to pretty clearly decide the outcome of this. Yet 2 of 3 judges on the Fifth Circuit found a way around it. Now, what's interesting is the one judge who dissented is also a very conservative judge. So it was actually 3 very conservative judges. One of the 3 conservative judges was like, this makes no sense, like based on this old Supreme Court decision, like the First Amendment prohibits this. But then you have the Fifth Circuit rule this way, and then the U.S. Supreme Court conservatives, in a different case in Colorado, once again limit civil liability, and yet they don't then apply it to the Black Lives Matter protest organizer.
Yeah.
Right. So there's like a lot of inconsistency here in which the Fifth Circuit finds a way first to not apply old precedent, and then the current Supreme Court finds a way not to apply new precedent in overturning this decision.
Real quick, was the Fifth Circuit decision a 3-judge panel and not en banc?
It was a 3-judge panel.
And so can the plaintiffs here seek en banc review?
Yeah, and I hope I hope they do. I hope that I think Sotomayor actually gives the invitation to the Fifth Circuit. She tries to give them the benefit of the doubt and says, look, maybe they didn't realize that after they ruled in that case, the U.S. Supreme Court in 2023 ruled opposite them, but they now need to correct that. So whether it is a rehearing before the three-judge panel, or it is a rehearing en banc, a reconsideration before the three-judge panel, or a rehearing en banc, this needs to get fixed because this is just a bonkers decision that will really curtail the ability of protest organizers to run large-scale protests without themselves individually facing enormous liability.
Well, so under this court decision that's going to remain in place, a protest organizer can then face disastrous financial consequences if even a single participant in the protest commits an illegal act. How does that not just serve as an invitation for some random saboteur to show up and screw over the organizer? So if you have a Black Lives Matter protest, for example, you have some white nationalist, one out of 100,000 who shows up and throws a brick at a cop.
Yeah, so it actually, and the dissent, this conservative judge in the Fifth Circuit who dissented actually points out another risk, which is that this also might incentivize police to be particularly aggressive at these protests because they have an immunity.
Right. And they can elicit some type of a reaction.
And then elicit a response,
yeah.
And then hold the protest organizer liable. But yes, so you could see it either in that there is a saboteur, or there's something that's instigated, or just in the course of a protest that involves tens of thousands of people, someone does something stupid.
Yeah.
And then the organizer finds themselves on trial for the damages. It is inconsistent with what we have understood the First Amendment to mean, which is, of course, if the person who throws the brick causes damage, that person can be held liable. But the person who has organized the otherwise peaceful protest for the purposes of expressing a point of view should not be liable.
Well, is the goal here then to impose some type of conservative chilling effect on all protests, given the liability that a protest organizer would carry?
Look, I mean, you and I could probably speculate or guess as to why the Fifth Circuit conservative panel came down they did. And again, I want to give credit to Judge Willett, who is himself oftentimes part of very conservative rulings that you and I wouldn't like. But he just thought this was crazy. I mean, he talks about the Boston Tea Party and the March on Washington and Martin Luther King. I mean, it's a very full-throated dissent. But we could speculate as what the motives is. But the consequences are clear, which is it's going to be very hard for a mass protest in the states covered by the Fifth Circuit to take place where you have an organization that has assets that is organized it. You have an individual who will be concerned. It'll be hard to get insurance, frankly. You know, oftentimes these protests have insurers who are insuring the protests. It's going to make protesting in those states a lot more difficult to organize because of the chill that will necessarily be in place, unless, of course, the Fifth Circuit picks up the opportunity to revisit this decision and reverse it.
Zooming out a little bit, what's the solution here? If given that the Supreme Court is the end of the line and that they're kind of refusing to just follow the law as it's written, to follow precedent as it stands, how do we protect Americans' right to peaceably assemble given the news that was just delivered here?
Look, I think it's a really good question. I also think that we have to be asking a parallel question, which is, you know, here's a Supreme Court that only hears 60 or 70 cases a year. And it seems like whenever Donald Trump needs a case heard, he gets the case heard. He wanted the case heard out of Colorado in a hurry. He got that heard in a hurry. He wanted the case involving presidential immunity heard, but not in a hurry, and he's getting that heard, not in a hurry.
Yeah.
You know, we just had a hearing in a January 6th case by one of the January 6th protesters to try to strike down one of the charges against the January 6th protesters that also would benefit Donald Trump. So you know, the Supreme Court has found a way to expand its docket to cover a lot of ground for things that President Trump and his supporters want, and yet here, where it involves civil rights or social justice protesters, and a really easy case for them to just summarily reverse, they can't garner the 4 votes on the Supreme Court to hear the case.
Yeah. Well, I know that you're following along with this case on Democracy Docket. So for anybody watching right now, if you want to be able to follow along, Democracy Docket is one of the most useful resources that I have right now to follow along with all of the cases happening in the courts right now. So if you're not yet subscribed, it's free to do so. I'll put the link right here on the screen and also in the post description of this video. I'm Brian Teller Cohen.
I'm Marc Elias.
This is Democracy Watch.